Next up, the battle over religious freedom versus claims of discrimination by a same-sex couple taking center stage at the nation's highest court. Tomorrow, Supreme Court justices will hear arguments about the case in which Colorado baker Jack Phillips refused to make a wedding cake for David Mullins and Charlie Craig. The couple, who married in Massachusetts, by the way, but were planning to celebrate in Colorado, accused Phillips of discrimination and filed a civil rights complaint. While Phillips argued that making the cake would violate his religious and speech rights and that therefore he has the constitutional right to refuse. Joining me to weigh in on that case and more is Margaret Marshall, who started it all on same-sex marriage. As former Chief Justice of the Massachusetts Supreme Judicial Court, nice to see you.
Thank you.
Remember all the way back as far as?
It was a long time ago.
So is this case about religious freedom and freedom of speech, or is it about creating a constitutional right to discriminate, Justice?
I would say the latter.
Why?
Because I don't think the court would have taken this case unless there was a problem that you may go the second way. And the facts, you always have to look at the facts. And so here are the facts from the brief. Yes, there was an order for a particular cake to be made for a particular marriage. Mm-hmm. But what the baker said was, I won't sell a cupcake if it's going to be used at a wedding. So even if you take the most fine definition that he was creating something and that is protected by the First Amendment, he was doing more than that. He was simply saying, if it's anything that comes from my store is going to be used in a wedding ceremony, I can't sell it.
Well, that makes me nervous. So that if what you seem to be saying is if the thing he didn't want to sell was more a product of his, quote, art, in which he would say that's a speech thing.
That's what he said, but the facts...
But if the facts in the case were, forget the cupcake, if it were just this creative work of cakemanship, for lack of a better expression, would he have a strong enough case to prevail here?
I wouldn't say so based on all the precedents. I hate to make the analogies, but I think we have to make the analogies, because interracial marriage, there were deeply held religious views that it was against the word of God for people of different races to have deeply held religious views. I mean, so those are the religious views. We would not sanction in this society that you couldn't make a wedding cake because somebody held a deeply religious views that a black couldn't marry a white or an Asian couldn't marry an African.
But the Supreme Court said you don't have to provide free contraception under the Affordable Care Act in the Hobby Lobby case if it turns out you have a deeply held religious belief, objection.
Of course. Now take this example. So you are a brilliant painter, I'm sure, hidden in there somewhere.
I would say probably not, actually, but go ahead, yes.
Anyway, and then you go to a gallery on Newbury Street to sell your paintings, right? And then you say, I don't want my paintings hung in a home where there's a couple. I mean, public, as soon as you take it public, over and over and over again, the Supreme Court. So why did they take it here? I hate to say this, but we're focused on Justice Kennedy again. It gets rather tiring, but that's where we are. And one of the pieces of the Obergefell decision, which is the United States, case, which he wrote, very well written, beautiful opinion, he made it clear in that opinion that nothing that the court was saying that sanctioned marriage or said that states couldn't block marriage could stop people from advocating their sincerely held religious views. And nothing that they couldn't be stopped from condoning. Watch that language very clearly. Now, again, if you take the original black-white decision, the interracial marriage decision, I cannot imagine a United States Supreme Court writing, well, we're going to let you marry, but by the way, there's nothing to stop you.
By the way, that Goodrich decision wasn't too bad either, by the way, speaking of the burger. Can we talk to judges for a minute? How worried are you when you open up the paper and see there are all these federal appellate openings, in great part because the Republican Senate wouldn't confirm or even hold hearings on the Obama things? This guy, what's his name? Brett Talley, 37 years old, never tried a case, never argued a motion, ruled unanimously unqualified by the American Bar Association, which is quite weird. The likelihood is good. He's going to be on the federal appellate court in Alabama. How much does this all worry you?
Oh, it worries me, and I'll tell you why it worries me. Not because of conservative versus liberal. I really don't mind that at all. But there is a consistent attempt here to find ideologues, and I mean ideologues who have decided what and how they will decide a case before they have the facts. I think that is a terrible decision. Right from the beginning, we have put the nomination of judges in the political branches, a governor or president. And that's where it should be, because judges in our system, unlike many others, can overturn a decision of a president or Congress. What you want is for people who will be independent. They can have conservative views. I mean, we've been doing that for years. You know, William Rehnquist was a conservative, I suppose, but he wasn't an ideologue.
Neil Gorsuch, is he an ideologue?
I would say that he comes from a background which, you know, he did a very interesting thing. When he was nominated, somebody said, when did you first think of becoming a judge? And he made the most revealing statement that I've ever heard, which was, when I was contacted by the Federalist Society. So you've got an organization of people who are going out to find people with particular views.
I want to ask you about a potential solution. Justice Breyer was sitting right over there a couple of years ago, and I asked him a question on one of my pet issues. Here's the justice.
I would say there should be a long tenure. Whether it's a term of years or not, maybe it would be better to have a term of years, but it must be long, because you don't want a person in that job thinking about his next job.
37 years old, Brett Talla. He could serve for 50 years through 10, 12 presidents. Should there be term limits on judges?
Yes.
And there should be.
Absolutely.
How long, if you were the in charge?
I would say, I agree with Justice Breyer, a long term, maybe 25 years.
How about mandatory retirement? You were subject to mandatory retirement because you left earlier, because obviously you left to take care of your wonderful husband, the late, great Anthony Lewis. Should there not be mandatory retirement, even though the Ruth Bader Ginsburgs would be subject to it? Yes. There should be. Why should there be?
You can do it either way. You can either do it by age, you know, Massachusetts is 70, you can do 72, or you can do it by...
Why should you have mandatory retirement?
Because you need institutional renewal, that's number one. The much more important thing, I think, is if you're going to appoint a Gorsuch or a Ruth Bader Ginsburg, what people worry about is that you're stuck with these people for 40 or 50 years. When the Constitution was drafted in 1780 around, you know, when, I mean, mass federal, people lived to age 50. 50. Now we're living to age 100. So if you appointed in your late 40s, which is often the case, maybe your early 50s, that's 50 years. I don't know if you know as much as your 14-year-old friend. You don't, right? They can deal with the world in a different kind of way. You need a lengthy tenure.
I'm totally with you. One last thing, we only have a minute left. Sexual harassment. Quickly going down the list. Did you experience it coming up through the ranks?
I don't think you should ever ask that question, because sometimes it's difficult for people to say yes or no. I was going to say, does a bear in the woods?
Okay, so that answers, and my apologies, but I'm glad you answered. Quickly, if you can, I'm going to make you the czarina of sex harassment in this case. You have unilateral authority to change law, change regulations. What's the single most important thing that should be done in this country? Not so that we're not just doing public shaming every day, which I think is important, but that can help fix the problem long term. What's the one thing, Justice
The one thing
Marshall?
that I would do is the following. If you're in a position of authority over anybody else, because don't forget there's sexual harassment, which is power, and there are also office romances, right? And it's hard to sort.
So what do you do?
If you're in a position of power and the person who makes the complaint, there is an irrebuttable presumption that it was harassment. Irrebuttable presumption. You proceed at your risk. That's
Makes me happy. Nice to see you, Justice Marshall. Pleasure as always. Thanks so much for your time.